Hi, I'm Dennis Orsey. I'm a sole practitioner from Granite City, Illinois, which is just across the river from St. Louis, Missouri, and I'm currently the president-elect of the Illinois State Bar Association. Today, I'm going to talk to you about the gubernatorial disaster proclamation that was issued by Illinois Governor J.B. Pritzker on March 9, 2020, and how it impacts on the Illinois Open Meetings Act and requirements for public bodies to meet. As everyone knows by now, we're suffering from a worldwide pandemic due to the coronavirus. Illinois is no exception. We've been impacted pretty hard here, and Governor Pritzker has issued a gubernatorial proclamation in which he's issued a stay-at-home order for Illinois residents. However, Illinois lawyers have been exempted from that provision, and specifically lawyers that deal with public bodies such as city councils, school boards, the work that I do representing police and fire pension funds. These are public meetings that are required to proceed to take care of the business at hand. For example, city councils are busy taking care of annual budgets. Appropriations need to be made to continue to fund the government or the school district. Plans have to be made, for example, for school districts when it comes to what their students are going to be doing in the next few weeks or months. And for my police and fire pension boards, they're required by state law to meet during certain designated time periods, one of which is the quarterly month of April. So in my practice, we're very interested in the governor's provisions on how public bodies are now to conduct their business. One of the provisions that the governor suspended in the Illinois Open Meetings Act is the requirement that members of a public body must be physically present. The Illinois Open Meetings Act requires that members of a public body be physically present when they conduct business. This is part of the sunshine requirements to make sure that the general public can see all those who are participating and what they are saying. Under this executive order, the governor has stated that individuals can participate in these meetings telephonically. Obviously, we're trying to maintain safe distancing requirements during the epidemic. So now they can conduct their business via telephone conference call, video hookups, or audio hookups, as long as the public is allowed to participate. And by that we mean the public would be notified through a posted agenda as to what is going to take place at the public meeting. Those requirements haven't changed. But now at the bottom of the agenda, it would identify how members of the public or press could participate. And that would be by indicating the call-in telephone number or the Zoom link up or whatever type of means the public body has chosen to do, so that members of the public or press have an opportunity to listen in and see exactly what the public body is up to. One of the other provisions of the executive order indicates when participants are allowed to be present. What I mean by that is, under the Open Meetings Act, there are certain requirements that in order to conduct a public meeting, a majority of the public body must be in physical attendance, and others can remotely participate as long as they comply with certain provisions of the statute. For example, under the Open Meetings Act, individuals who are members of the public body could participate remotely if they were sick and in essence had a doctor's excuse for not being there, or if they were called away for business and couldn't be physically in attendance. Those are a few examples. Under the governor's executive order, he has suspended those rules so that all members don't need to have an excuse. All members can participate remotely as long as they follow the provisions of notifying the public that they are going to conduct a meeting and how members of the public or press can participate in that meeting remotely. As I mentioned earlier, the governor issued his executive order regarding the disaster declaration on March 9th, 2020. Originally, that declaration held through March 30th, 2020. And then on April 1st, 2020, the governor extended through another executive order all the provisions through the end of April of 2020. So the provisions I've talked about in terms of suspending certain provisions of the Illinois Open Meetings Act follow the governor's disaster declaration. So when we reach April 30th, were the governor to extend that declaration for an extended period of time, these provisions suspending parts of the Illinois Open Meetings Act would remain in place. On behalf of the Illinois State Bar Association, I want to tell all lawyers in the state of Illinois that we stand with you. These are unprecedented times for everyone in the world, certainly for our legal community. And we want to make certain that lawyers know that they have a place to go. One of the things the Illinois State Bar Association is offering during these troubled times is an opportunity for attorneys to catch up on their mandatory continuing legal education requirements. So the Illinois State Bar Association has opened up to all lawyers, including non-members, 10 free hours of CLE programming. You simply have to go to our website at isba.org and follow the instructions. We know statistically over the last few weeks, literally thousands of lawyers from around the state of Illinois have taken advantage of picking up on their MCLE credits. So while you are sheltered in place, while you are working remotely, this is a good opportunity to meet those requirements. Again, we look forward to the time we're all going to get back to our normal practices and representing our clients face to face. But in these troubled times, we hope that all ISBA lawyers and practitioners around the state will be safe and healthy, and we wish you well.